Well, welcome. Good morning, good afternoon for some. Thank you for joining us today for our SVDX webinar. The title of which for today is Directing the Wind, Climate Governance and Boards of Directors. SVDX, for those of you new to our webinar series, we are an organization dedicated to education and networking programming for boards of directors. I encourage you to visit our website to see past webinars and to check out our calendar for future programs. I would like to say a special thank you today to Heffernan Insurance for co-sponsoring today's event. We are very pleased to have you as one of our sponsors and delighted we were able to put together today's session. This will be a 1-hour webinar. We encourage you to submit your questions via the Q&A feature on Zoom. We will hopefully be able to answer them throughout the program, but we will also have a Q&A period at the end of today's session. And finally, we will be recording today's webinar, so you will be able to access it on our website at a later date for viewing once again, or you're welcome to share it with colleagues who aren't able to join us this morning. And with that, I'd like to pass off the baton to our moderator today, Joe Talmadge, who is with Heffernan Insurance. Joe, off to you.
Thank you, Nancy. And I'll start off by saying we're very, very pleased to be partnering with the Silicon Valley Directors Exchange. We, Heffernan Insurance, are one of the largest brokers in the country, specializing in private to public D&O, and our interest in corporate governance is very high and promoting educational content in those areas. So we've done many, many programs over the years with the Silicon Valley Directors Exchange and are very pleased to be here today. We have a really great lineup with Tom, Heather, and Lisa. I'm going to let them each introduce themselves, and then we'll kick it off and get into the Q&A in and around this wonderful topic of climate governance. Lisa, do you want to go ahead and take the first intro?
Sure. Hi, everyone. Lisa Edwards. I'm president and COO of Diligent Corporation. Many of you probably use our board portal for your board meetings. However, we also have a full suite of GRC products, governance, risk, and compliance, and have gone fairly deep in climate with Scope 3 emissions modules and a climate certification process for board members who are looking to get more educated.
Tom?
All right, I'm Tom Garcia. I'm Chief Administrative Officer at Deckers Brands, which is a publicly traded footwear and apparel company. Our main brands are UGG, Hoka, Teva, Sanuk, and I've been with the company for over 13 years and worked very closely advising our board and have been in the boardroom for over 20 years. I'm currently responsible for leading our ESG program, our global legal as general counsel, and our business development strategy functions. And before Deckers, I was in the medical device industry as well. And excited to be here.
Great, thank you, Tom. Heather?
Hi, I'm Heather Palmer. I'm a partner in the environmental and energy practice in Sibley's Houston office. I'm with Sibley Austin. I'm a lawyer. And I also am the co-chair of our global ESG practice and our global climate change practice as well. And so routinely advise clients with respect to ESG related issues, including disclosure of ESG related items in their public filings.
Great, thank you. So Heather, I think that's a really great background to actually have you lead off the panel. There's a lot of discussion in and around climate and disclosure. The SEC released a new proposal. I think it'd be really helpful to get the panel started off with summarizing the new SEC climate proposal, and then maybe you and or Lisa could comment and highlight on what you think the general mindset for board members in what they should take in tackling this topic.
Sure. So I think it's important to note that the SEC's rule proposal is one of the most significant developments in U.S. securities law in recent decades. This is not just another proposal. The proposed rules would require public companies with periodic reporting obligations and companies filing registration statements to provide very granular disclosures regarding greenhouse gas emissions, climate-related risks and impacts, oversight of climate-related risks, climate-related goals, and climate-related financial statement metrics. And certain of this information would also be subject to attestation or independent audit requirements. And, the purpose of the rules from the SEC's perspective is that they're trying to satisfy what's been significant investor demand for climate-related disclosures that are consistent, comparable, and reliable. However, it's important to understand that, if these rules are adopted as proposed, it's going to compel companies to incur significant costs of compliance and to put in place robust monitoring, accounting, auditing, planning, and governance practices to satisfy the extensive disclosure requirements. So let's talk about some of those requirements. The proposed rules would mandate disclosures concerning a company's direct greenhouse gas emissions, also known as Scope 1 emissions, their indirect GHG emissions from purchased electricity and other forms of energy, which are known as Scope 2. But in addition, it goes beyond that, and registrants would also be required to disclose indirect greenhouse gas emissions from the company's value chain, known as Scope 3 emissions, if material, or if the company has set Scope 3 emissions targets or goals. And the proposed rules, if adopted, actually go well beyond the statutory or regulatory requirements of any other federal agency, including the U.S. Environmental Protection Agency, in requiring the quantification and mandatory reporting of Scope 1, Scope 2, and under certain circumstances, Scope 3 greenhouse gas emissions. So a lot of you are going to need the services that Lisa's company provides in terms of being able to, track those emissions. The proposed rules would also require companies to disclose climate-related risks just beyond their own operations, to include the actual and potential impacts beyond the company's financial statements and operations, and extend disclosure to the company's value chain. And that includes both upstream and downstream activities of the company, and include its suppliers, distributors, and investments. So basically, you're going to look who's in front of you in line, who's behind you in line, and what are all of their climate impacts, and how is that going to impact your company. Most significant for boards, the proposed rules require that registrants disclose certain information concerning a board's oversight and management's governance of climate-related risks. And those disclosures would include information regarding the processes by which the board and management oversee and account for climate-related risks, and how management reports to the board on these issues. So you'd have to disclose things like the identity of board members or board committees responsible for the oversight of climate risks, including whether any board member has expertise in these issues, the processes and frequency by which the board or board committees discuss climate risks, how the board is informed about these risks, and how frequently the board considers such risks, whether and how the board or board committee considers climate risks as part of its business strategy, risk management, and financial oversight, and whether and how the board sets climate-related targets or goals, and how it oversees progress against those targets. And so I think that, as we think about the rules and governance issues and what important issues with respect to the board, I think that, an interesting and potentially challenging aspect of the proposed rules relates to the mandated disclosure of board processes, including how the board considers climate-related risk as part of its strategy, risk management, and financial oversight. As you know, board processes are typically dynamic. They're not static, and they may vary based on the board's agenda, external factors, and issues that may arise. So as board processes evolve, it's unclear how frequently the SEC would expect a company to update its disclosures with respect to board oversight. I'm going to turn it over to Lisa to share some of her thoughts in terms of, what this could mean for boards. But I think that as you're thinking through this, boards are really going to want to understand the steps that management plans to take now to begin preparations for compliance. If the board has not yet been briefed by management as to the proposed rules, expansion of the disclosure requirements, and the potential need for additional resources, board members may actually want to consider requesting a briefing on these issues sooner rather than later.
Yeah, so I certainly agree with that, Heather. And I should have noted in my intro that I come from this from the lens of, we have 25,000 customers who use our board portal, and we interact with them all the time. But I'm also a sitting member on the board of directors of Colgate-Palmolive. And, I think a lot of board members are on the page where, I think we all can agree that it is the job of the SEC to make sure they're mandating the disclosure of material risks. And right now there's a lot of voluntary disclosure out there. So there's good certificate systems like TCFD and other ways to CDP, other alphabet soup ways to disclose. But in the end, I think the thought is there's this mandatory reporting about material financial risks is a normal course and speed for boards to have to deal with, and the essence of the regulators making sure that investors have the information and risks they need and can make financial decisions based on those. So, as it relates to board members specifically, it's also incumbent on board members to become educated on this or any other material risk to the company, and so becoming educated and conversant on the various disclosure regimes. They change; they're different than they were 5 years ago. This new change that we've just been talking about is different than some of the things that you could have said 6 months ago about this. So, thinking about, are we up to speed on what some of these various rules, regulations, frameworks, disclosures, whatever those may be, and how do we use those to have intelligent conversations in the boardroom to hold management accountable and be able to provide that oversight role? So the questions and the mindset is, based on these rules, and I think we'll talk a little bit about whether they will stand as is or there'll be some challenges to them. But I think that the writing is on the wall that some sort of disclosure on these risks will be required by companies, and boards should be asking themselves, do we have the expertise? I think it's also important to note that in this environment of not just climate but ESG, you can't just add, somebody who is an expert on diversity, somebody who's an expert on greenhouse gas emissions, somebody who's an expert on other types of emissions. Building that fluency on the board, thinking about how you consider it in what committee owns it, and either reports out to the broader board or does the whole board own it. These are the kinds of things that board members should be thinking about as they look at tackling the new regulatory environment.
Thank you both. Lisa, you mentioned potential legal challenges that this might see. I was hoping maybe Heather, you could expand a little bit on that. I want to be cognizant of maybe not mentioning specific company names, but just more broadly speaking in terms of what we might expect.
Sure. So we really expect that legal challenges on the climate rule are pretty much going to be inevitable. Even before the SEC proposed the rule, a number of market participants had indicated that they would challenge a rule in courts, in the courts if the SEC moved forward. And unfortunately, there's a lot of uncertainty as to the timing of these challenges and where they might end up. First, some type of injunction or stay stopping the rule right after it's adopted is probably not very likely. The reason for this is that the standard for an injunction or stay is fairly high. And it's not clear that challengers will be able to show, the irreparable harm that would be required to get such a stay or an injunction. And challengers can't simply meet the standard by just pointing to high expenditures. You can't just say, this is going to be too expensive for companies, therefore the court needs to stay the rules. Second, what these legal challenges are going to look like precisely is going to depend on the final rule itself. And so until the final rule is published, that's when the lawsuits or litigation can be filed. And so a lot of it, it's going to depend on what the final rule actually looks like. And then a third complexity is that litigation on the rule is going to be complex. There are likely going to be numerous challengers across the spectrum of companies. So when you sort of start thinking about the timeline, the public comment period is open until May the 20th. And then the SEC, will consider all of the comments that are filed already. There have been a large number of comments that have been filed. We're working with a large number of trade associations and individual companies as they're preparing comments to the rule. The SEC has stated its, intention to issue final rules before the end of the year. We'll have to see whether that actually happens. But then, as I mentioned before, that's when, legal challenges would begin. But as you're thinking about this, for the largest companies, compliance would be required as early as 2024. And that requires disclosure of climate-related risks for fiscal year 2023. So for a lot of the data that would be required with respect to greenhouse gas emissions, for example, all of that collection would have to start in January of 2023. So while we're likely to see legal challenges to the final rule, there is a great deal of uncertainty as to whether those challenges, would actually succeed. And without an injunction or stay that stops the final rules from becoming effective, companies will need to be prepared to comply with those rules while the litigation is pending.
That's super helpful, Heather. You mentioned earlier that the rule is pretty broad in scope relative to maybe what some other federal agencies have out there already. Can you share if you're aware if the SEC is coordinating with other federal agencies to support the proposal, the EPA, Transportation, Department of Labor, State, Treasury departments?
Yeah, we're not hearing much from the SEC about coordination with other federal agencies to support the proposal. The SEC does refer in the proposed rule to the EPA's mandatory greenhouse gas emissions reporting rule. That's referred to in the proposing release, but there's no indication that the SEC coordinated with the EPA in advance of the proposal, or that there's sort of any kind of ongoing coordination that will take place as part of the rule. We haven't heard that the SEC has been doing that outreach. Doesn't mean it's not happening behind the scenes, but it hasn't really been in the public spotlight.
That's helpful. Thank you. Well, that's quite a bit of risk to consider. I'm going to pivot and ask Lisa specifically in and around Section 11 claims and how boards should be thinking about this as it relates to climate disclosure requirements.
Sure, and I should preface this with I am not a lawyer, nor did I even take pre-law in college. So, but from where we sit and from where so what I have seen from our boards and the feedback that we've gotten on this, I think starting from, what do we have to do already and how does this fit into the existing framework of what boards have to think about is the way that I look at this. And companies today are legally required to disclose things that a reasonable investor would find financially material and refrain from misleading investors. And so if you start from there and you say, should we anticipate issues around shareholders with, looking at individual officers and directors for failing to oversee climate and social risks that are rooted in state law and Delaware law? I think yes is the answer to that. And some of that is starting to creep in small ways already. And so looking at how you think about failure to disclose risks in federal security law. So Securities Act of 1933, we're all familiar with. Securities Exchange Act of 1934, directors and officers are subject to Section 11 liability for material misstatements and omissions. So are you failing to say something that you should have disclosed? Similarly, liability for statements made, whether that's in your S1 on your IPO or material statements and omissions for your filings like your 10K, your 10Q, other public statements. The liability is when a plaintiff can tie a drop in share price to a material omission or false misstatement. So that's a pretty high bar. That said, some of these things have started to come through in the ESG space. So there have been lawsuits where statements about the code of on the ESG side about a code of conduct and what was said around the code of conduct versus things that happened in the company. You've seen things like that in failure to disclose kind of bro culture. You've seen that in failure to live up to some of the things that companies have stated about their position on racial diversity. So in that same way, when companies have been out there making statements about where they are on climate, and weirdly, I'd love for Heather to comment on the current rule. There's an oddity to it that almost the more proactive you have been in disclosing and in getting out there and saying, we're going to try to do something about this, we're going to try to set goals around this, you're almost held to a higher, different standard, that it's almost punitive to the companies that have been proactive and trying to kind of embrace this thing. So I'd love to have Heather comment on that. But so I think like as a board member, and for the board members on here, if it helps you for having a mental filing cabinet like it helps me, think of it as, for what we would have to do anyway, prohibiting material misstatements and omissions, and prohibiting the and failing to disclose risks. If you put it in that bucket and think of it that way, it becomes a lot more clear what the course of action for the board is.
Yeah, and Joe, I don't know if you want me to follow up on what Lisa was saying, but
Sure, yeah.
it definitely is something that we've observed with the rule, is that basically the people who have, the companies that have been proactive, that have set their aggressive goals with respect to, net zero by 2050, let's say, or sooner, and intermediate goals, and companies that have really been thoughtful and established, for example, conducted a, climate scenario analysis, or they have their carbon transition plans, those companies actually have to disclose more. So the more that companies have done, the more disclosure that they're going to be required to do. And so it is, as Lisa said, a very interesting aspect of the rule. It almost, for companies that haven't done these things, it's almost as if it's a chilling effect. And I think that maybe there might be that chilling effect. They're like, well, wait, I'm not going to set a goal as to scope 3 emissions, because then I'm going to have to do all these things. But I think that, particularly I think there's going to be a lot of pressure from investors and even sort of peers and competitors in terms of, setting the expectation around what a company will do. And then in some way, you're getting kind of a check mark next to your name if you're not doing some of these things.
That's really helpful. So kind of carrying on that idea of the expectations on disclosure, I think one of the I don't know if Lisa or Tom would be best to sort of answer this question, but where does climate disclosure fit in the sort of broader enterprise risk matrix, and how should board members be thinking about the internal processes and controls in and around climate, given all of those sort of factors?
Tom, why don't you go ahead and I'll follow up.
Sure. I would say, climate and, frankly, a number of components of ESG, for that matter, are absolutely part of enterprise risk management. And depending on which committee takes the lead on risk management, usually it's the audit committee, those risks associated with ESG would be overseen there. Now, of course, how you're thinking about the processes internally to, before they bubble up to the audit committee is really important. What types of risk committees you have, whether it's an internal audit function as well. But aside from that, I think, I was just talking about risks, how you oversee what the vision looks like, the strategies, the initiatives, all of that's a whole different ball of wax, and I think, a governance committee oftentimes is a good place for that, but it really depends on the company and where those the skills are, as Lisa noted earlier, within the organization. But I think as you're thinking about ESG and climate, it is so big. I mean, I think we didn't even talk about this yet. All the various components of this are so big, and it's so far-reaching throughout the organization. It's complex, and there's just no one size fits all approach, in my opinion.
Yeah, I agree with that. And I think, the risks are, when you talk about climate disclosure, the disclosure risks are some of the things that Heather just talked about. Like, in some ways, disclosing sort of requires more disclosure with the way the rules are currently written. We'll see if that sticks. There's also there's no special risk on disclosure aside from failure to disclose in some cases. And some of the oil and gas companies have been challenged on, like, what does climate change mean for the viability of your business long term and things like that. There's the risk of putting something out there that's untrue, and that's an existing risk that boards of directors have. And then I would just wholeheartedly agree with Tom, it just fits in the enterprise risk matrix. So all of us have the heat map. all of us have the things that we look at to say, high probability and high impact, and where does climate fall in that? That's going to be specific to every company and industry because of where they sit, what materials they have, and how literally it impacts them. So if I have a series of factories, or all of my factories at sea level, I need to disclose that moving those would be a material, cost to the company. If there was sea rise, then people need to be thinking about things like this. So it should be, but it should be handled in some ways in the same way that any other enterprise risk. And I think we've seen just these emerge onto enterprise risk matrices this year in interesting ways, especially with climate becoming more important and more credible as we've seen sort of the evolution of that, and then even just other risks around pandemic. I don't think any of us would have put a pandemic high into the right on our enterprise risk matrix 2 years ago or 3 years ago, but there it is, right? So I think it's an evolution, and thinking about how that component pieces of climate enter that risk. But from a disclosure perspective, the disclosure itself is just subject to those same risks that we just talked about in terms of what a board is required to do, and that's just failure to disclose or disclosing something that's materially incorrect.
Thank you, Lisa. We have a question in from the audience. Assessing one's indirect greenhouse emissions seems like a difficult and lengthy process where one will have to trust one's trading partners for the disclosure. Is that a fair sort of assumption and assessment? Does anyone have an opinion on that?
Go ahead, Heather.
Yeah, no, definitely. So it's definitely going to be a situation in which you're going to have to trust your partners. We expect to see. So what's interesting about the rule to consider is the fact that a lot of folks view it as being, okay, this is the SEC, so it applies to public companies and doesn't extend to me if I'm a private company or if I'm private equity, for example. But what's going to happen is the fact that private companies are going to have to provide this level of information to their customers, and because the companies are going to need this information from their suppliers, and so it's something where the rule itself is going to be very, very broad and far-reaching. But yes, it is going to be very challenging, especially for companies that have a huge supply chain that's on a global level. It can be very challenging to try to, calculate these emissions. Now, there is a safe harbor provision in the proposed rules that exempts smaller reporting companies from the requirement. And there's also, some, safe harbor, liability protection. And there's a longer lead time with respect to when you have to report Scope 3 emissions, even from you get an extra time period. And also there's no audit or attestation requirement around Scope 3 as the rules are currently proposed. So the SEC did consider, the fact that this is going to be challenging. Folks had told them it was going to be challenging when they submitted comment letters last year to the SEC on, when they were sort of in advance of the proposed rulemaking. But I think that a lot of our clients have concerns about whether, there are enough protections and whether this type of reporting is going to create a lot of headaches for public companies.
Yeah, I agree with that. And, I think there are ways to help with it. So, we have a product that traditionally has been used for third-party due diligence around, is it a politically affiliated party, all that kind of stuff. We are incorporating climate things into that to see if there's reputational issues around climate with the supply base. So there's sort of some puts and there's some checks you can do. But I want to underline something that Heather said that I think is so interesting is I do think a lot of private companies are saying like, this doesn't apply to me. And guess what? It definitely applies to you, because first of all this just sort of trickles downhill. But secondly, as you look at, a publicly traded private equity firm making statements about their portfolio, they're going to start checking that portfolio. They're going to start saying, you need to report to me, and then I in turn need to report to my investors. The other thing that is starting to become more interesting is, for example, last fall, you saw Carlyle come out and say we're tying $4 billion of debt and the to diversity and climate initiatives on boards of directors. So thinking through, whether if the cost of your debt is tied to climate, you need to care about it. If you have to disclose it to your venture capitalists or to your private equity owners or to your institutional investors, you need to care about it. So this is definitely one of those things that there will be a trickle down effect from public to private, and sooner rather than later, if you are a private company selling into a public company, which I think most people would want to do.
Thanks, Lisa. Heather, could you expand on the safe harbor proposed under the rules? We have a question from the audience that wanted a little bit more elaboration on that.
Sure. So for the Scope 3 emissions disclosures, the proposed rules that have a safe harbor from certain forms of liability under federal securities law. So specifically, disclosure of Scope 3 emissions by or on behalf of the registrant would be deemed not to be a fraudulent statement unless it's shown that such statement was made or reaffirmed without a reasonable basis or was disclosed other than in good faith. And so the safe harbor would extend to any statement regarding Scope 3 emissions that is disclosed pursuant to subpart 1500 of Regulation SK in an SEC filing. So it's, there is some protection there, but it's not necessarily some of our clients plan to comment on the rule with respect to that not being enough protection.
Great, thank you. So both you, Lisa, and Heather mentioned, companies dealing with this. Are there specific companies that we can look at today or that are already dealing with legal challenges on climate issues, or maybe specific lessons that boards could learn from these companies?
Heather may want to be careful with that, with her.
Yeah, I'm sorry, Heather. I didn't mean to put you on the spot.
No problem.
Maybe if Heather wants to comment in generalities, I can comment on a couple that are in the news that people will be familiar with. I think on there's been several on the sort of utility companies and oil and gas. So here in California, where I live, PG&E is sued by shareholders, and that was around failure to disclose risk for contributing to fires. So I think you probably could tie that back in some way to this failure to disclose risks and climate change. You have some of the oil and gas companies that have been held to, have the board misrepresented the risk of climate change. So that was Commonwealth of Massachusetts, Exxon was the first one of those, I think, but I would defer again to the lawyers in the group. But certainly, if a board makes a big public statement to say we have no tolerance for X, and then they do tolerate it, that's a shareholder could come in and say, listen, that's not true. And I think that's where going back to this risk of disclosure. I think being appropriately careful with the language used and the disclosures made is important. It's always important for boards, particularly in this sort of brave new world of climate. Choosing those words very carefully, and what the company is standing up for, and what the company is sort of setting as goals is incredibly important. And I would say, more so if you are in an industry that is more impacted by climate-related issues.
And, following up on that, Lisa, I guess there are a couple different points I'd make as well to keep in mind. And one relates to, in a recent article, Leo Strine, who's the former Chief Justice of the Delaware Supreme Court, warned that ESG, which would include climate, should be viewed as an extension of the board's duty to implement and monitor an effective compliance program and related system of controls. And this also suggests that a failure to attend to important ESG matters in a way that harms the company may give rise to a breach of fiduciary duty. And this may not be a hollow warning, given that in the past 2 years, we've seen a rise in the rate at which breach of duty claims from compliance oversight failures has survived motions to dismiss. And so, part of this exercise in terms of disclosure, or as you're thinking about climate risk, is based on your particular company and their unique positioning. Would any of these types of risks be viewed as mission critical, such that then from a sort of a breach of fiduciary point of view, could it be argued that somehow the board had oversight, or their oversight responsibilities should have been more rigorously exercised? So we've seen that not necessarily in the climate space, but you've seen it in like safety related issues, in various situations in which there have been claims that have been brought against, boards based on, an alleged failure to, have that, to have that oversight of their mission critical regulatory or safety related risks. And, it's interesting in some of those cases, it was the board's failure to assign responsibility to a specific board committee that was also kind of the focus of the court's decision to allow those cases to proceed. And then the other thing that I just want to mention is with respect to shareholder activism. We're seeing a lot more activist campaigns that are really focusing on climate issues. And in this latest proxy season, the number of climate change proposals filed is nearly doubled. So based on some of the success from last year's proxy season, where the proposals that did make it to a vote, the average support for climate proposals exceeded 50%. Activists have become more emboldened by that support, and we're seeing sort of a record number of climate change proposals this year. So it's just something for boards to keep on their radars as well, is that this is really being used as a strategy to garner support for, certain climate issues, climate lobbying reports, political activity reports, carbon transition plans. We're just seeing a lot more pressure on companies these days with respect to activism as well.
Thank you, Heather. We're at about the halfway marker. I just want to give the audience a heads up. We're going to be transitioning into talking more about vision and alignment at the board level in just a moment. I want to cover one more topic before we go in that direction. Most of this has been focused on risk and compliance and disclosure. We are going to transition out of that and solicit more input from Tom in and around that alignment and vision. Before we do that, Lisa and Heather, you mentioned the phrase "depending on the industry" a few times in your sort of commentary. For industries outside of oil, gas, and energy, specifically, I'm in San Francisco in the Bay Area, tech industry. Are there other considerations that boards that are not in sort of traditional energy related sectors, how they should be thinking about climate governance, whether that's, the impact on domestic energy, labor, transportation, housing, these sorts of things? Lisa, you're on mute.
It was so smart too. The short answer is absolutely. The longer answer is, obviously on an enterprise risk matrix, if climate change is an existential risk to your business, it's different than if it is, sort of one of many risks. And where I kind of think of it in the technology industry. That said, I think some of the technology industry has been very, very forward on sort of declaring positions on this. And so if we go back to the very start of this, where we said companies that have been set their net zero targets, been sort of on the forefront of making the disclosures, the impact of if there's greenwashing involved in that is there's certainly a risk there. But back to the issue with supply chain and scope 3 as well. Technology companies are selling into all of these companies that are at risk as well. So as those companies start to review their supply chain and review the companies that they can do business with that help them move the needle in a positive way on Scope 3 emissions, then technology companies from a business perspective will want to slot into that. So there's both sort of the same risks on disclosures and doing what you say, saying what you do. There's risks to being able to sell into companies if you don't have the proper posture on your emissions, and then there's just the regular sort of material emissions and failure to disclose.
No, that's great. Thank you, Lisa. Now, I think just to follow up on my commentary, I want to take the sort of risk and reactive mindset, hat off and talk about the opportunities that all of this is presenting. We have some questions from the audience. How do we actually understand the company and the impact on the ESG world, or how the company is impacting the ESG world, understanding, evaluating, and actioning our actual impacts. This question is from the audience. I think I'd like to also pose directly to Tom, in your experiences, how companies should think about setting a vision, driving continuous improvement, and establishing value that is ultimately created out of these efforts. And anything that you can sort of share in your experiences about aligning not only the organization, but also, the board, the executive leadership of the company, management, employees, as well as any other stakeholders on ESG related matters. And that's a big topic to cover. So I'll shut up and let you talk.
I'll see what I can do. Yeah, aside from risk and disclosure, obviously incredibly important. I think it is important to reframe the discussion a bit around how to create value. And I think the organizations and companies that are striving to lead in the climate space and the broader ESG space are beginning to get recognized. And it's not just by your shareholders and not just by consumers or your customers, but it's also by employees and prospective employees. And as we look at, this competitive employee environment, it is making the difference absolutely in hiring decisions and bringing people on. Those that are setting the vision, setting meaningful targets, being transparent about the progress against those targets. It really just doesn't go a long way with candidates. And, I think as far as setting the vision, that is a process, and creating alignment. It's not something that happens overnight. And I think it's important for those that are beginning this journey, or even any point in the journey, it's important to realize that it's going to take time and it's not going to happen overnight. But for an organization to, one of the first steps in setting a vision is taking a look at your operations and understanding where you're having an impact on the globe, right? It's not just climate, but you can evaluate your organization against the UN SDGs, Sustainable Development Goals, and determine where you can have the biggest impact within those individual pillars, and then drive progress against them. But that's sort of like the first step, but there's a lot that goes into it beyond that. But I think as far as aligning the organization, I got to tell you, the biggest impact that I've experienced and I've observed is when the tone from the top, from the board of directors, is very strong, and it flows down appropriately, to management, and the CEO, executive team, and beyond are consistently talking about climate, consistently talking about other things, ESG. It truly gives permission to the employees to make the change, because these things don't happen with one individual leading with a handful of people on a team. This is something that can be impacted throughout the entire organization, and it actually needs to have that impact. When we're talking about Scope 3 down through the chains of the of an organization, it's pretty far removed from the highest level, and you really need to make sure that the people throughout the teams are thinking about it, and it becomes embedded in the culture, right? So that individuals are expected to drive change, expected to bring up opportunities. And ultimately, I believe that this is something that ties into culture in a way that's incredibly strong for these organizations and drives, retention and et cetera. So I hope that helps a little bit.
Yeah, no, that's super helpful. So, and I think it's important to understand the ultimate sort of opportunity and that this is proposing to companies in general. Most of this discussion has been surrounded around risk and compliance and reacting to what's happening. But I think you bring up a very important point, which is this very clear opportunity that organizations have in front of them. So I do want to ask, we're getting close to the end of the webinar. I'm going to do a circle up through the panel on questions that each of you think that board members should ask on climate and any resources that directors should consider as they try to educate themselves in and around climate issues. Tom, since you just sort of kicked off on the opportunity, if you have resources that you've used or things that you'd like to comment on that would be helpful for establishing and taking advantage of those opportunities, I think people would be welcome to hear that.
Yeah, I think, as far as questions go, I think the first question, truly for the board is to look internally first. Are we really bought into driving change? Are we really, or is this just a disclosure type of thing? Are we bought into it? And do we have the right skills? Have we looked around the room, and where do we need to educate ourselves to get up to speed to really make the change that's necessary? And then you have to push that down through the organization, through the CEO, senior management, et cetera, and then make sure the vision, you're driving towards that vision. I think as it relates to external resources, there's a lot of I don't have any specific one. It depends on what area you're talking about within ESG, but I think if ultimately you need to assign the right leaders to drive this and make sure it's espoused throughout the organization. That's a key component.
That's helpful. Lisa? You're on mute again.
Can't help it. I got a dog. So I think I agree in general. I think it is what metrics are material to the business. And by the way, that's more than just climate, right? So depending on the company, that might be, plastics, that might be water, that might be whatever. So while this covers climate so probably the first priority, you can't sort of ignore these other components. How do you tie those metrics back to the business strategy of the company for both risks and opportunities? And how do you measure and manage that? And then how as a board, do you use the levers that you have, which is, what are you asking the right questions? Do you have the right oversight of of what's going on, and oversight in the sense of tracking, as well as is there third-party assurance? And some of the Diligent Institute data that we have we look at proxies of the Russell 3000 as well as 2,000 companies in Europe. We see an increasing amount of companies seeking third-party assurance, even before these SEC rules were coming in. A very small number of those are actually with what you call the traditional auditors, majority with sort of small boutique-y, more consulting firms specific to greenhouse gas emissions. So thinking through as a director, where are the assurances happening, and are they happening? And then again, how do we compare to our peers? So are we good? Are we good on an absolute basis? Are we good as it relates to who we would consider peer groups? And there's ways to get that data today without having to, sort of wait for some of these disclosures. For example, a lot of companies do voluntarily disclose CDP that's available on their website. So there's ways to go and say, what do we look like versus our peer group, and to use those to start a boardroom conversation on do we have a proper level of oversight? Are we looking at what's measurable, and are we using the levers available to us, executive comp, reporting and asking the right questions to make sure that we are attuned to this. And I guess one more would be, do we have fluency on our board? Which is, honestly, the reason why Diligent did director certification on climate was because I felt like I didn't have what I needed. And so now we do. But it is, you don't have to have world-class experts on greenhouse gas emissions, but you do need to be able to ask the right questions. And that means a certain level of fluency on the board in what the issues are, what the standards and frameworks are, and how the company is addressing them.
Lisa, before Heather, you give your commentary, you're talking about fluency on the board in and around this topic. We have a question from the audience in terms of, understanding the fundamental levels of the cause and effect of secondary effects on the full chain reaction of energy consumption and climate chain reactions and the actual measurements and the final effects on the climate. There's a lot of directions that this can go. I think, how do you think about that in terms of board level fluency in and around this topic?
So I saw the question and I was trying to read it while we were all talking, and I was I got a little confused in there, but
yeah, I think my take on the question is that you can dive really deep into the sort of secondary effects and just go all the way down to the fish in the Atlantic Ocean if you want.
Right. So where does it all stop?
Yeah, where does it stop, and like what kind of fluency are we looking for? Yeah. So
I think when I say fluency, it is first of all, things like scope 1 emissions is obvious that a company should get their arms around, and scope 2, scope 3, if you've been disclosing those and you've been making public statements on how you're doing on those, is another one. It doesn't mean that you have to understand the nitty gritty of all the bits and pieces of scope 3. The same as it doesn't matter. Like if you are a world-class CMO and you have joined a board of directors, I don't think anyone expects you to be, able to, dig into the minutia of the income statement. However, as a board member, you're expected to come up to speed on the financials of the company. The audit committee has the deep expertise on that, but everybody is expected to, be able to be conversant in it. And that's what I mean when I say fluency. I don't mean that you have to understand, the 300 different acronyms out there and how they've all come together. And last week, these two combined into something new, which keeps happening. Every time you get up to speed, by the way, on all these acronyms, they change. So beware of that. But no, I think you can go down a bit of a rabbit hole, and the same way as a director, you would not go down a rabbit hole on any other thing in the company. Your job is not to go do it. Your job is to oversee it. So what level of conversancy do you have to be able to ask the right questions and get some assurances when those answers come back that feels right to you?
Thank you, Lisa. Heather, I'm going to go ahead and let you finish off the last 5 minutes before we round up the panel with final questions that you think directors should be asking, as well as any resources that you think are really important in educating on this topic.
Okay, well, I'd say just in terms of, I think Tom and Lisa have done an excellent job in sort of talking about it from kind of a vision standpoint. But then when it sort of comes down to brass tacks and compliance with what the SEC is going to require of public companies, I think it really is very important for boards to start considering, if you don't already have a committee that's assigned to, these types of risks, thinking about, okay, what's going to be for the full board to consider versus whose charter are we going to tweak a little bit in order to cover these types of risks? Also asking questions of management in terms of understanding how management actually, how internally the company is organized, who's overseeing it from a management perspective. How often do you want reports to the boards? Is this something that should this be an annual basis? Should this be something that's a regular agenda item based on, the expectations that the SEC is setting in terms of initially getting up to speed with these types of disclosures? Is it something, and particularly, maybe even it's the audit committee that's focused on this, but does the company have the internal controls and processes in place for this type of disclosure, and making sure that the disclosures that are being made are, accurate and correct? So it's sort of from a practical standpoint as well. It's just sort of trying to decide in terms of the cadence, who's going to be responsible, how often, and how is that reporting sort of going to flow, and how is the company and the board going to make sure that, you know, it's complying and that the disclosures that they're making are correct.
Great, thank you, Heather. Nancy, I'm going to go ahead and hand the panel back to you. I want to thank Tom and Lisa and Heather for all of your commentary today. This has been really, really insightful. And again, we're very grateful for the participation with SVDX and all of your commentary.
Thank you, Joe, and I'll second that. Thank you so much, Lisa, Heather, and Tom. Really appreciate your time, your participation, your very wise counsel. Joe, as always, thank you so much for your participation, your moderation, and thanks to all of you for joining us today. We look forward to seeing you hopefully in person someday soon at another SVDX program. Have a wonderful rest of your day, and thank you again. Bye-bye.